Well, it's a good morning from me, and it's a good morning from him, and all those good things. Welcome to my mortgage live stream. Just about getting used to that music now, aren't I? It's taken me a month and a half. Hey, do you know what happened 5 years ago this week? It was like the beginning of COVID. Do you remember 5 years, all that lockdown nonsense that went on? Terrible, wasn't it? Starting to see some TV shows now where they're referring to the pandemic. I was watching Unforgotten last night, brilliant series, and they're talking about the pandemic and pubs closing and everything. So, yeah, life moves on. Interest rates, of course, down last week, which was all factored in, or they call it burned into the fixed rates anyway. But hey, it's good news, and maybe it'll pick things up as we continue this year. It'll be lovely to think so. Talking to a few brokers out there and mortgage advisors, getting busier. They love being busy, of course. A few of them are looking to, increase their sales force and get some new people in as well. But it may well start to go from what I call the hose pipe, with the water where you can drink it quite easy, can't you, to a fire hose where you've got this water gushing out and you can't drink it all. So if you haven't segmented your market, thought about your specialization area where you focus on your value proposition, your marketing. And remember, when you get busy, don't stop marketing because you'll get boom and bust. You've always got to be marketing all the way. But we know these things. A couple of updates for you on some technical aspects for your CPD and a little sales skill at the end for you as well. A smart influencing technique, which I think you'll like, actually. It's not salesy, it's influencing, and that's the whole secret, isn't it? So we're on live to YouTube and LinkedIn and all those things. So let's just confirm that we are on air so that people know that this is live and not pre-recorded. Hope you're well. Hope you're enjoying yourself. And the evening's getting slightly brighter, although that is the theory. I don't know if it's actually happening in practice, is it? So we've got three topics for you today, one after the other. On insurances, I've got contract law for you, the law of agency and consumer insurance. You might think, oh, that's a bit heavy, Paul, but let's just kind of highlight it, bring it to life. Great for your CMAP, of course, or for those of you doing your CPD. So without any waiting around, let's get over to the whiteboard. Shall we do the first one for you? Here we go. Over to our whiteboard. Now, I've pre-prepared this one with the word contract law, and that's what I want to take a look at with you for a couple of minutes. Contract law. Now, when it comes to contract law in the CMAP and financial advisor, mortgage advisors world, there's a few uses where contract law comes into its own, and you kind of need to understand a bit about it, really. So where are the uses of contract law? Well, first of all, when you take out a mortgage, you have to obviously complete a mortgage deed. The mortgage deed is the contract between the lender and the borrower, the mortgagee and the mortgagor. And that's a contract in its own right, so you have to adhere to contract law for that. Also, if you're in the buy-to-let area, your clients may well have tenants that have to complete a tenancy agreement. My two sons done one of these recently. And a short hold a tenancy is a contract. Again, the rules must apply for that as well. And also, if you're in the protection world, which you should be, of course, life assurance products are also effectively a contract. So there's plenty of uses or applications of contract law. So what is contract law then? Well, first of all, a contract has to be either written or it can actually be verbal. Which seems a bit odd in a way, doesn't it? So you've got your written contract here, which is obviously in writing, versus verbal. Both are perfectly acceptable. Let's put that in there for you. Both are perfectly acceptable when it comes to contract law. Written contracts obviously are more enforceable. A verbal contract's great, but then you've got to remember what people have said, unless you've recorded it, of course, along the way. So what needs to be in place then for a contract to be applicable and correct? Well, there are a number of features really for a contract. The one that crops up in the exam a lot is the offer, acceptance and consideration. So let's put these over here for you. There are effectively offer, acceptance and consideration. Let's just put those up there quickly for you. These are the three aspects of a contract that make it legal. So what are these then? Well, one of the best examples, it's not strictly correct, but it helps you, is when you go shopping into Tesco's, for example, and you're going to buy some cornflakes, say, or some granola if you're a bit healthier. What happens, of course, is you go into the store, and when you go to the shelf, which is displaying the granola, That's, if you like, the supermarket, Tesco's, offering you some products. So as far as contract law is concerned, they're offering you a product by looking at the shelf. You then accept that product by putting it into your shopping cart, your wheelie shopping cart that's got all your shopping in it. That's acceptance of the contract. And when you get to the till, if it's a self-service one, of course, you pay for it and you use your debit card to pay for it. That's the consideration. So that's actually not a bad way of looking at how a contract works, really, as daft as that sounds. But if we get more official on this one and take a look at life assurance, which is really where it's at, isn't it? Life assurance. Let's just put that over here for you. There's these three in action, as you can probably appreciate. First of all, the offer, if I just put that down there for you, is where in life assurance terms you fill in the proposal form. So that would be the offer, would be the proposal form, wouldn't it, if you think about it, filling in the proposal form. The acceptance, here we are, would of course be the acceptance note issued by the insurance company, the acceptance letter as it's often known as. So when you propose yourself for insurance, you then get accepted. Actually, the consideration, to put that one here for you, is effectively when you've completed the direct debit mandate. You've actually accepted the offer, if you like, the debt. You don't even have to have made your first payment, but actually filling in the direct debit mandate is your consideration. So that's how that works with life assurance. Makes sense, doesn't it? What else needs to be in place then for an active contract to be in place? So let's just put an example here. You're going to go into a parking lot run by a private company, and the parking company has put all the terms and conditions on there for you. And obviously there's the pay machine down there where you have to pay. Now that's a contract, because if you don't adhere to the rules, because you're entering into a contract, then you can be fined, and often you are, aren't we? So what has to be in place there? Well, first of all, you have to have what's called capacity to enter into a contract, which generally means over the age of 18. There are some exceptions north of the border, but generally speaking, you have to be over the age of 18 and of sound mind to enter into a contract as well. Now, the terms of the contract have to be clear. They mustn't represent anything or be free of jargon, that kind of stuff. You must understand the terms and conditions, which is often how lawyers can get you out of parking fines, because some of these terms and conditions are not very easy to understand. That mustn't be any misrepresentation. There you go. Of the rules and terms and conditions as well. And finally, of course, the contract must be for legal purposes, like parking a car is legal, isn't it? Taking out life assurance is legal. So there's got to be a few conditions attached to it really there as well. And that's pretty much contract law, really, as far as the CMAP syllabus is concerned. And you'll get a couple of questions in the exam on that. Hope that's been of use. Okay, well done. So that's just an update for you on contract law, just a little extra there for you if you're doing the exam as well. Let's pop across now to the other whiteboard. We're on a bit of a roll here. I want to take a look at the next one, which is consumer insurance. So let's pop over there now and get on with this one straight away. Already pre-prepared this whiteboard with the words there, Consumer Insurance Disclosure 2012, which sounds rather heavy, doesn't it? But actually it's quite interesting. Because in the old days, before this law came in, I call it old, the old way of doing things, you had this thing called the duty of disclosure. Now, the duty of disclosure, let's just put that up there for you, disclosure. And you had utmost good faith as well, which is still there as well, utmost good faith, were ancient insurance laws, which pretty much put the onus on the customer to disclose everything that was needed for the insurance company to take on the risk. And if they missed stuff, then the insurance company could refuse to make the claim. But that, you see, is wrong, really, because the customer doesn't really know. So here's your typical customer here that is trying to make head or tail of this insurance rulings, and they're all confused by the terminology, etc. If the duty is on them to disclose everything the insurance company needs, and it must be obviously the truth and whole truth, nothing but the truth, it can go wrong. And in the past, there were issues around people not disclosing all their medical details, or they missed a doctor's report, or maybe if they claimed for cancer on their critical illness, they might have had a rash on their arm at some point, which they just put down to the sunburn or something, which then eventually led on to cancer. And the insurance industry wasn't getting a very good name for this. So they changed it, which, is a good thing. So what happened, therefore, is they brought in this new act. So they changed everything. So new, there you go, was this consumer insurance legislation. The key thing here is there was no more duty of disclosure. That was pretty much abolished now, and it put the onus back on the insurance company to ask the right questions on the forms. That was the key thing, really. So it did just change everything. So the insurance company's got to ask the right questions. Now, obviously, the client's still got to answer them correctly with utmost good faith and all those things. Of course they do. They can't pull the wool over the eyes, can they? Because that's fraud. Now, as a result of this, the insurance company, of course, has to ask the right questions, get all the right information. But customers still sometimes do miss things out, don't they? Deliberately, maybe, or not. And then there's two issues that came from this one. The customer could just be careless in their answers, or, of course, they could be deliberate. In other words, they deliberately, let's put that in there for you, they deliberately don't answer the question correctly. Now, in those cases, you see, if the customer deliberately doesn't ask the question, here we are, if it's deliberate, can be proven, then the insurance company, of course, can refuse the claim. This is a perfectly acceptable thing for them to do. Makes sense, doesn't it? Refusing the claim, you think about it. If it's careless, at the top there, in other words, if they didn't mean to get it wrong, they just did, or they forgot genuinely, then they could probably reduce the amount of the claim, for example, or the very worst thing, refuse the claim but refund the premiums. So there are some ways they can make it slightly easier. I mean, for example, if you just forgot about a doctor's appointment in 2022 and you hadn't written that down on the form, because you generally forgot, but then you see the doctor might have issued some problem with your health. So they could refuse the claim and maybe just refund the premiums. But if you've deliberately misled them, of course, that's fraud for all intents and purposes, and they can certainly refuse the claim. Has it made much difference? Not really. It's made the proposal forms a lot bigger, and more questions the insurance company asks now. But hey, at least the onus is not on the customer anymore. It's on the insurance company, where it should have been in the first place. Hope that's been useful. Bye. Nice one. We're on a bit of a roll here, aren't we? Getting some of this terminology and stuff done for you. Last one for you. I bet you can't wait. The law of agency. So let's pop over to the big whiteboard for this one. The law of agency is what I want to take a look at. So let me just get rid of this for a moment or two as we go into the law of agency. So I hope you're all well. Hope you're enjoying your February. We've got Valentine's Day this week, haven't we? So don't forget all your loved ones. And send a Valentine card to your lenders and brokers and people like that, because you do love them, don't you, at the end of the day? Anyway, law of agency. The law of agency. Now, what are we talking about with the law of agency? Well, again, there's plenty of uses here in financial services world. There's lots of situations where we have an agency. We have an IFA, for example, who acts on behalf of the customer. So that's the big one, isn't it? An IFA is a big use versus a restricted advisor. Now, restricted advisor is somebody used to be called a tied advisor. This person is restricted to one provider's products. So the IFA acts on behalf of the client. The restricted advisor acts on behalf of the company in which they work on behalf of. The other example you've come across, of course, is the estate agent. Estate agents, of course, sell properties, we know that. But they've got the vendor. Now, the vendor is the fancy name for the person who's selling the house. Now, the estate agent acts on behalf of the vendor. They're the people that are paying the fee to the estate agent. You might be viewing a property and the estate agent might be very nice to you, but they're not you're not their client. So as far as the law of agency is concerned, estate agents act on behalf of the vendor. So how does this happen legally then? Well, first of all, you've got two characters here. So let's just put those up for you. You've got the agent. So let's just put our agent in here for you. There we go. We'll give the agents. There we go. There's the agent. There you go. We give him a little bit of hair, shall we? There you go. So he's the estate agent, or the person who's doing the work effectively. But then on the other hand, you've got what's called the principal. So let's put her in there, shall we? Yeah, big eyes, big smile. There you go. There you go. Pearls there for you. We'll give her a big bouffant, shall we? Do you like the hairstyle? Now, she's not known as the principal or the principal. Now, what happens in the law here is that the agent will act on behalf of the principal. That's the whole point. They act on behalf. In other words, the actions they take, there you go, are on behalf of the principal. And that's quite important in law, really, because it's recognised in law that has been accepted. Obviously, there's contracts and signatures and stuff like that required as well. So how does this get monitored and looked after? Well, first of all, you have to have some written authority as such. So let's just put this down here for you. The authority is the written document which gives the agent the authority that they're able to operate from. So if it's an estate agent, they'll act on behalf of the vendor. So, who you can take round the house, how offers are going to be put to the principal, and any other information that comes through as well. And you can't exceed that. You can't go over the authority. So let's put that in there for you. You cannot exceed it. Otherwise, you're acting illegally, effectively. And of course, the vendor want to make sure they're not exceeding their authority. And I guess some estate agents probably do. And in that case, they probably get around if they've exceeded authority, they'll probably get around it by using the principle of apparent authority. Just put that over here for you. Apparent authority. Now, apparent authority is where the agent thinks they have authority because they swear blind that the principal told them verbally. So, for example, if the estate agent's taken on an offer and the offer is at the asking price, the estate agent might say to the applicant, yeah, you can have it, it's yours, it's the asking price, because they reckon that they got apparent authority to accept that. But the vendor may not have said that. They may, I want you to get more. So that's known as apparent authority. Very difficult to prove it, of course, because it's often verbally as well. But the principal might say, well, use your initiative when it comes to it. So it's often the initiative that's used in those situations. Now, when we get into larger situations, you can ratify the authority after the event. In other words, if somebody's gone on their behalf and they've used apparent authority, they've used their initiative, that could be ratified afterwards and added to the authority, just to tidy things up, really. That's pretty much the law of agency. There's not much more to it than that. A couple of key words here. You've got the agent and the principal. The principal is the person who's the important one. The agent acts on their behalf. Estate agents is a key example, but the IFA is another key example that they use a lot in the examination as well. So hope that's been useful. Bye. Brilliant work. Okay, just some updates there for you, just to sort of update some of our videos on Bootcamp. Is what we're doing there for you. As you know, we have the CMAP Bootcamp, which covers the whole syllabus in little video clips like the ones you just seen. So if you're interested in that, we've reduced the price this year actually to give more people the chance to get their CMAPs up and running. So we're quite pleased with that product. It works really, really well. If you, like me, if you get fed up with me, you may not want to watch it, but that's fine by me. Anyway, let's go on to our last topic for you today, which is a little influencing technique that I want to share with you, which I think you'll like. It's very subtle, but very clever, actually. I think you'll like this one, or not, as they say. This one's called a smart influencing technique. Now, this one's called preloading your requests. Now, this is useful when guiding people to do what you want them to do. Now, our middle son, Ewan, when he went to Reading University a few years ago, he gave me this phrase that they used all the time. It meant preloading. What it meant, of course, was inhaling cheap booze from the supermarket before you headed out to the clubs and pubs of Reading, where, of course, the alcohol prices would make your jaws drop. Now, when he mentioned this preloading, I immediately thought of the NLP tool called pre-framing, which I talk about a lot, don't I? Now, here's a couple of examples for you of how pre-framing can help you when influencing people, particularly when you're fact-finding or exploring the needs of clients. So before you start the meeting, you use the phrase, Mr. Brown, Mr. Brown, before we start officially the meeting, can we have a chat for a couple of minutes? Now, this relaxes your customer dramatically, and they may let down their barriers and give you information that might help you. Interesting, that, isn't it? During the meeting itself, I'm going to ask you a ton of questions because I need to get a perfect picture of your situation to help me move forward. Now, that phrase gives you no excuse at all to ask some exemplary questions. And before we start, I'd like to tell you how we're different to the competition. Now, again, that might open your customers' eyes to why they need to do business with you before their walls go up. It's that phrase, before we start, that's really important. I mean, preloading, whatever next. Now, in my day, you could only buy booze from pubs anyway, and the opening hours were so restricted, we never had time to preload at home beforehand. Great, I hope you enjoyed that little session there for you as well. So that brings us to an end then of our live stream this week. Again, we'll be here next week with some more updates for you and all those good things. As always, let's just give you the QR code that you can use to gain access to our member database. Lots of stuff going on this year, as we've always said. Lots of freebies and webinars and videos. Get on to our Mortgage Advisor Development Hub and we'll keep you informed of loads of free things to help you in your mortgage career. So you can obviously use the scan button there as well. Let's get out of the way so you can see me. Other than that, I'm going to wish you to have a fantastic week, everybody. Enjoy yourself and let's get some daylight going and some sunshine, shall we? Other than that, have fun all and we'll see you next week. Bye for now.